New friends, new opportunities, new partners. E.g. Tax.
Some estate planning, wills, trusts, that sort of thing. But, and real estate, and some litigation. But also, I do bankruptcy. And quite frankly, in my advanced years, I find bankruptcy probably the most satisfying. So I wanted to talk about that, and that's what I'm billed at. I have a four-letter word for you, and it's a bad word: debt. Debt comes from a Latin word that means debt. And it's something to be avoided if you can, but it's difficult to live without. Debt has been described as a trap that a person sets by himself and then deliberately gets into. Debt is the source of a lot of grief in families. In fact, as somebody said, in many instances, marriage vows would be more accurate if the phrase were changed to "until debt do us part." Okay. And who said this? This is a quote: "I am the king of debt. I understand debt probably better than anybody." Anybody know who said who? Exactly. Some wag said, "Let us all be happy and live within our means, even if we have to borrow money to do it." And somebody else says, "If you think nobody cares if you're alive, try missing a couple of car payments." Anyway, like our opinion about the opposite sex, you can't live with it, can't live without it. And debt is something we need. We need it for, if you want to buy a house, most people don't have tens of thousands of dollars lying around loose. Or the ability even to buy a car and pay cash, at least not in the early days of their lives, when they most often need a car. The problem with debt is that if debt is too high or income is too low, that's a problem. Excuse me. Debt can be too high because of spending choices, and that's often what we think of a person who's going bankrupt. Oh, they just ran up a bunch of bills on purpose, and now they're just going to go bankrupt and stiff everybody. Well, that doesn't happen too long. As a matter of fact, the years I've been doing bankruptcy, virtually all people who come in to see me and everything have unforeseen problems that has occurred. Unforeseen obligations that suddenly occur that change the financial picture for them. Or it turned out their income was too small because of circumstances, income change. A divorce, illness, accident, loss of a job, those are what lead a person into a crisis situation, and they need to do something about it. Debt is something that works fine if you keep it in balance. In other words, you have debt and you have future income. And as long as your future income stays ahead of the debt, you're in good shape. But if the debt becomes too large for the income that you're going to get, then you're faced with some minimal alternatives. If you have a problem paying for your debt, that's your problem in paying. By the way, it's the creditor's problem in collecting. What the creditor wants is just for you to make that monthly payment, which you agreed to do and everything. So what can creditors do about it? Well, they can forgive the loan. That's unlikely, but if they're friends or they're relatives, that's okay. But that's not where we get our big money. We get our money from the bank. Now, we either get it from the bank for a large real estate deal, where it's you're buying a house, or you're buying a car, or you're maybe dealing with a variety of banks because you use a credit card for a lot of purchases and that sort of thing. Well, if a creditor has a problem with you not paying, they will sometimes extend time for you to pay and stretch things out a bit. Also, they may, under certain circumstances, simply accept less. You owe $20,000, they'll take 12 or something. And that occasionally occurs. In fact, I represent people who are being sued by banks for credit cards and trying to help them be able to work this thing through without resorting to bankruptcy. Creditors will eventually have to sue. Some creditors are more anxious to do it than others. And some creditors pounce right on it, like American Express, frankly, has got a reputation now for kind of sue first, ask questions later. And you should understand that a lawsuit by a bank to collect on a credit card is not the same as an accident lawsuit, which can take a couple of years. Creditors can get a judgment against you fairly quickly. Oh, there may be some defenses in the odd case, but it's rare that you can come up with something that really thwarts the efforts of the creditor to get a judgment against you. The alternative is for the debtor to seek opportunities for maybe increased income. A second job is a typical example of that. Or maybe somebody in the family who hasn't been working goes out to working, or a part-time worker becomes a full-time worker. The other opportunity might be to pay with other money. When I say other money, again, friends and relatives might come through and help bail you out, or you could take it from your retirement, IRAs, 401ks. Not a good idea if you can avoid it. And you could incur additional debt by, let's say, taking a second mortgage out or something like that. That basically doesn't really solve the debt problem. It just kind of moves the debt around to different resources. But the ultimate alternative is bankruptcy. What is bankruptcy? It's a legal proceeding brought in the U.S. bankruptcy court designed to protect an individual or a business debtor that cannot meet its financial obligations. And it's also designed to protect the creditors. What does it protect the creditors from? It protects the creditors from, let's say, the other creditors. So that the person whose minimal resources are looking to be grabbed by the creditors, that there can be a more even-handed treatment and a fair treatment of competing creditors. It's all governed by a federal law called the Bankruptcy Code. It governs all bankruptcies in every state. And yet, each state can be somewhat different in terms of the parameters of bankruptcy, because even though it's a federal law and a federal system that does it, it relies on more local law, state law, that governs certain aspects of what they can take, what they can't take. And by the way, the various chapters that you hear of course, refers to the chapters in the Bankruptcy Code. Chapter 7, Chapter 11, Chapter 12, Chapter 13. In a Chapter 7 bankruptcy, also called a straight bankruptcy or a liquidation, the court appoints a trustee. They take the debtor's property, assets, except for exempt property. They sell it and they distribute the cash amongst the creditors in a proportionate manner. And then the debtor receives a discharge, or a release from most of what they owe. They don't have to pay them. That's a Chapter 7. The other chapter that we hear about in consumer bankruptcy is Chapter 13. That's different. It used to be called a wage earner's plan. It's a debtor actually submits a plan to pay the creditors some or all of the debts over a 3 to 5 year period. There are 100% plans where you pay everybody off, but you take time to do it. Or there may be some plans where you take some time to do it, but you're only going to pay them out 50%. It depends on what your resources are and the nature and extent of the debt. So why would somebody do a 13 if they could do a Chapter 7, which allows them to pretty much walk away from the debt and be completely free? Well, they made a rule, which is about 2005. They changed the law and they said, some of you have to do a Chapter 13. You have to make this effort to pay back creditors. And if your household income exceeds the median income for the geographical area you live in, you have to file a Chapter 13 and not a Chapter 7. So what's the median income for one earner in New York? Happens to be $53,000 and change. Two people, $68,000. Three people, $80,000. And four people, $98,000, and so forth. So the more people you have in the house. I've had some people who unfortunately make too much to be able to do a Chapter 7. They have to do a Chapter 13. And I say, gee, if you could somehow add one more person in your household, preferably somebody who doesn't have any income, you might qualify for a Chapter 7. And I've got, at least one couple where they're waiting for a new person to arrive, scheduled a few months ahead, and I'm going to wait until that number's up until we actually file. So that can work out. But there's reasons to do a Chapter 13, even if you're not forced to do a Chapter 13. For example, if somebody, let's say, 6 months behind on their mortgage, well, it's tough to make up. But you can do it with a Chapter 13 because you can set this thing as two different debts, saying, look, I got my monthly amount I have to pay, regular mortgage payment, but I got this 6 months of arrears. I'm going to take that 6 months of arrears and stretch it out over 3 to 5 years. And that's a way to catch up. Some car loans, for example, if you have a car for more than 2.5 years, you're allowed to actually reduce the amount of the loan, the balance due, if the car is underwater, so to speak. In other words, the car is worth less than what is owed. So you can even eliminate something, sometimes a second mortgage on your house if the value of your house is reduced somewhat. We don't see that too often right now because, well, prices are up, it's a seller's market, etc. But a few years ago, we did see kind of a flat real estate situation in Western New York, and some people were able to show that they didn't have enough to even pay anything for the second mortgage, and so that second mortgage was alleviated. For the not for the average consumer is Chapter 12, which is reserved for family farmers and fishermen. And gotta admit, I've never had one of those. And then, of course, there's Chapter 11. We hear about Chapter 11 with corporations, large businesses, which essentially isn't the same because not just the type of bankrupt organization, but also they don't get a discharge from that. It's mainly a matter of getting things reorganized so that the company isn't taken apart by the creditors. So the next question that usually arises when people come in is, am I going to lose all of my property? And the short answer is no. You're not going to lose all your property because a lot of your property is exempt. Exempt means the trustee can't touch it, can't take it. Most clothing and furniture falls into that category. And the equity in a home is significant. It didn't used to be years ago where you maybe get $10,000 off or something like this, but now the home equity is up to $85,400 is exempt. That's just if you're a single person. If you're a couple, you can double that. $170,800 for a couple. And you don't get much of a deal if you don't own a house. It's only about $5,000 cash, but there's some others that you can kind of add to that. But that means you can have a $300,000 house in which you have a $150,000 mortgage, so your equity is only $150,000. If you're a couple, you get to keep the house. Keep the payments on the house, of course, but you get to at least keep the house. You're allowed to keep a car up to $4,550. That's again per person, so we can sometimes have two cars and two exemptions for that. Also, your pensions, IRA, most life insurance policies, 401ks, that sort of thing. they are 100% exempted. So, which is something when you think about the idea that a person's faced with some debt is saying, I gotta pay off this debt. I owe this $30,000 to my credit card companies and that sort of thing. I'm gonna pull $30,000 out of my 401k and I'm gonna pay. Then they come in to see me and I say, wait a minute, why don't you think about this a little bit, because you might be able to go bankrupt. Keep that $30,000 in your 401k and walk away from your obligation to pay off the credit cards. And as a matter of fact, in the typical bankruptcy, often there is no property that is not exempt. Everything is exempt. And accordingly, they're even called no asset bankruptcies. And that's a very common phenomenon. So the trustee is not going to take anything out of it. Okay, what happens to the property that is not exempt? Well, a trustee can take that property, including cash, bank accounts, other assets. He may choose not to take property. For example, you say, well, look, I got a 1999 Chevy. It's got 175,000 miles on it, and right now it's in my yard up on blocks because you know, the thing doesn't work. It needs a new engine, something like that. You can pretty much guarantee that even though you own that car free and clear, that the bankruptcy trustee has no interest in it at all. He'll simply say, that car you can keep, okay. There may be other things like, let's say, a small business. There might be some minimal assets, maybe even some accounts receivable or something like that that you're trying to run or something like that. But in terms of actual assets, they might be quite limited. The trustee might say, I'm not interested. In some cases, they say, well, okay, look, you got a boat, and boats aren't exempted. You're going to have to pay, you're going to have to do something about the boat. Either I'm going to take it and sell it or whatever. Well, they look at the boat and they kind of evaluate. The trustee may even send somebody out to take a look at the thing and put a price on it. And he says, well, look, it looks like a $3,000 boat. And you somehow come up with some money, either from a friend or relative or pulling it out somewhere, and say, look, how about I give you $1,500 or $2,000 for it? The trustee may say, $2,000 will be good. So you turn over $2,000 and you keep your $3,000 boat. By the way, income tax refunds that you're waiting for, they belong to the trustee, just like cash and that sort of thing. So it's good to file your tax return and collect the refund before you actually file bankruptcy. If you're doing it later in the year, it becomes a little more complicated and you have to try and get it exempted some way or another. Chapter 13, you get to keep probably whatever property you want to keep, even though it's not exempt. But you have to pay enough during the course of that 3 to 5 year plan so that the creditor gets as much as they would get if the property were sold out from under you and the cash then paid to them. It's called the Chapter 7 test, and if you pass this Chapter 7 test, well, you can keep anything, which of course is one of the reasons people do a Chapter 13. Now, what kind of debts are discharged in a bankruptcy? There are several types of debts here. First of all, secured debts, such as a home mortgage and auto loan, of course. They're guaranteed by liens on their house or car. That's why I call it secured, because the creditor has the grip on your property. Now, you can avoid that debt, but you're going to have to give up the property, and some people do. They've got a car that's got a payment of $450 a month, which is beyond what I'd ever want to pay. But in any event, if they say, I'm not going to be able to make it. That's one of the things that got me in trouble before. I'm going to give up the car, so you can allow it to be repossessed. And now that secured debt is now an unsecured debt, and you can walk away from it in a Chapter 7. And unsecured debt, of course, are typically what we think of as credit cards, medical bills, and just miscellaneous debts of various kinds, unsecured debts. There are no liens guaranteeing them, and of course in Chapter 7 you can walk away. There are also some non-dischargeable debts that are not dischargeable after bankruptcy just because of the nature of the debt. And then probably the one that I hear about constantly is the school loan, because I get people coming in to me and they say, I've got all these credit card debts and everything like this. Oh, when I have a school loan, I owe $80,000. You know, well, gee, I would love to be able to help you out, but unless you have an extreme hardship, which is tough to prove, you're not going to be able to do it. Now, I've gotten some people out of a school loan, and one of the first ones I did was a young couple who I don't know how to put this more charitably, but they were not the most attractive couple I'd ever seen. Okay, and they had both incurred a school loan for going to modeling school. Okay, so I was able to argue that they had a hardship and that sort of thing. And I frankly think that once the court took a look at this couple, they agreed and they got out of that loan. But for the most part, you don't get out of your school loans. And there's a lot of talk about changing that law. Yes, sir.
Okay, question on it. That student loan, is it wise to maybe take a credit card, pay off what you can, and then file bankruptcy on that credit card? I know it's kind of crooked, but I mean, it's...
That's, first of all, that's exactly what I think would be probably the best course. But it's just difficult to slap down the credit card and pay for school, particularly when you're talking about making a couple of $1,000 payments every semester or something like this. In the meantime, keeping up with the payments, which is the only thing that keeps your credit card alive, is the payment, minimal though it is, and that sort of thing. In the long run, it may be better, but you know, the schools and the banks and everything else are saying, oh, why don't you take a look at this school loan? We'll give you thousands and we'll give it to you, and you don't have to pay anything. It'll be all deferred until you start making the big bucks after you get your degree in art history or something like that, and you get a job, you know, a lucrative job. Well, see, some people are not getting the lucrative job, and they're getting it deferred longer, but they still owe the dough, and they're not going to get out of it. Some people are, frankly, I think, are putting it off with the idea that Congress will eventually come to their rescue. Remember, school loans used to be freely dischargeable and that sort of thing. Then they put a limit on it. They said, look, you can get them discharged, but you got to pay them for at least 7 years. Say, okay, fine, did that. And then Congress said, that's it. We're not going to allow them to be discharged at all. Now, there are some programs or something. If you go and work for a not-for-profit or a government agency and you make payments for 10 years, you can get the rest of it forgiven, which is pretty decent. But you've got to have the right degree and the right that sort of thing to be able to get the kind of job that goes along with that sort of thing. So I've often thought if you could somehow shift that debt, pay off that debt with something that is dischargeable, like a credit card or something like that, you would get out of it. But that's very difficult to do, and I've never seen anybody really be able to do that. Also, domestic relations type debts, alimony, child support, and even a chunk of money that constitutes payment for a division of property in a divorce or separation. That is not dischargeable. It used to be that the paying off for a portion of the property was dischargeable, but paying the support and the alimony was not dischargeable, and they would have, and I've been through a trial in bankruptcy court over that very issue. Was it in one category or another category? Well, Congress wiped that out and said, look, if it's something agreed to be paid or directed to be paid in a divorce, you're done. It's not dischargeable. And anything fraudulent, and by the way, if you use your credit cards, I had one client who he gets all set up, he gets his paper into me, we're preparing the petition, and meanwhile, unbeknownst to me, he's out there using one of his credit cards, getting cash advances to the tune of about $3,000. And of course, we file the bankruptcy, and the bank sends us a letter saying, this doesn't seem appropriate. Cash advance right on the eve of bankruptcy? That's right. In fact, cash advances or purchase of luxury items within 90 days before the filing of bankruptcy are presumed to be fraudulent, you know, that you really intended to go bankrupt and not repay the loan. Well, so I tell people, look, if you need to use your credit card between that 90 days, first of all, it's best if you didn't. But if you do need to use the credit card, make sure you confine it to socks and underwear and not for ball gowns and mink coats and stuff like that. So, and that's the subject here of all the credit card debts dischargeable, and those are the exceptions to that rule. Now, what is the process of declaring bankruptcy? First of all, it's preparation and filing of a petition and schedules. The schedules show all your assets, all your income, all your obligations, your debts, in other words, and all your expenses. And that's, of course, what makes up the whole thing. It's evaluated and by a trustee. You also have to do one other step. This was also introduced in 2005 when they had the new law there. They said that everybody who files a consumer bankruptcy, Chapter 7 or Chapter 13, have to go through debtor counseling. And they can go to a local debtor counseling agency, sit down in a little classroom and go through the thing, and they could be charged $50 for that. And then after you file, but before you get a discharge, you got to do through a second one called a personal financial management course. Usually the same people give that kind of course and that sort of thing, and they charge you another $50. Well, interestingly, it got very competitive. So now I give people a card to say, look, call these people. You can do the whole thing online. It'll be $10 for the first one, $10 for the last one. And if you're a couple, you do them together, it's only one $10 and a $10. So that's pretty simple process, and they get people started on that. Whether it does any real good in terms of making people better managers of the money, that I don't know, but it is a requirement. Anyway, after the petition is put together and before it's filed, clients come in and they sit down, we go through each item, and I have them review it, make sure the figures are right, and they sign the thing in several places. And then we file it. We file it electronically. And that date of filing, that is when you have declared bankruptcy. And the date of filing is the important thing. Now, what happens then is, at that point, all collection stops. If you're getting calls, they have to stop. If you're getting letters from creditors, that has to stop. If they've sued you, they have to stop suing you. If they're thinking about suing you, they might as well stop thinking about it because they won't be able to do it. It's not only is it ineffective, it's also illegal and can be a violation, subjecting the creditor to fines if they did it knowingly and stuff like this. Most banks and everything are sophisticated enough to know that it's not something they can do. So that gives some people a great deal of relief because they're getting nothing but endless phone calls about their particular debts, and they're afraid to even answer the phone. So next is the meeting with the trustee. Here's the trustee. Doesn't really look like that, but in any event, yes, sir.
You say something about
Filing fee. Yes. Filing fees in bankruptcy court for Chapter 7 is $335 for either a single person or a couple that can file jointly. And if it's for a Chapter 13, it's a little less, like $310, that sort of thing. Now, typical fees for a bankruptcy would be something in the area between $1,000 to $1,500 for Chapter 7. More for a Chapter 13, typically about $2,000 to $2,500, but some of those fees can be worked into the plan for a Chapter 13 plan, so the person making monthly payments is also paying part of the fee for the attorney, that sort of thing, so it makes it a little easier there. The trustee is the person you meet at the first meeting of creditors. It's called the first meeting of creditors, but Usually there's only one meeting. And actually there are no creditors that appear. The only one is if you've got some local person who you're, you owe money to a neighbor or somebody like that, they might show up because they don't understand the rules. But the banks don't bother to come. The first meeting of creditors, after it's been filed, it usually occurs about a month after the filing. When you appear, you just identify yourself, your attorney's at your elbow. You identify the fact that you signed these petitions, and the trustee typically asks a few questions about some of the answers that you put on your petition, and little more. And then the simplest bankruptcy, it lasts just a few minutes and you're out the door. It's a little more complex if, let's say, you have some business income or you have some rental income, you have some strange situation that requires a few more questions to be asked. And for the most part, you don't have to come back. You may have to require, if the trustee wants a few extra documents, you say, well, you'll send them and that sort of thing. But that's pretty much it. Now, Chapter 13 is somewhat different because you're sitting down with the trustee who does nothing but Chapter 13 and has a staff that does it, because remember, the Chapter 13 involves a plan, a payment plan. Well, the payments go to this Chapter 13 trustee. And that's his full-time job. He just does nothing but that, and his office processes these payments. And they get some say in terms of whether they think that your plan and the monthly payments you're going to make are adequate and sufficient. And if they're not, they'll say so. They'll say, well, you want to pay $500 a month, but you're gonna have to pay $600 or it's not going to work. And so you see how they crunch the numbers, and you say, okay, that's fine. You kind of go in with that in mind.
Is there a set percentage on Chapter 13, or is it just basically what they feel as though?
Purely what, it depends upon what your ability is. There are standard expenses that they get from the IRS that says that, look, this is what you ought to be paying for your shelter. This is what you should be paying for utilities. This is what you'd be paying to put gas in a car. You can point out exceptions in your need for the exception applying to you, but for the most part, they follow those guidelines. Apply that to the income that you have, and do you have money at the end of the month, okay? If you do, that money is supposedly going to be dedicated to paying towards this plan. Now, for some people's situation, it may be enough so that over 60 months, 5 years, that'll pay off everybody 100%. That's a 100% plan. Some people, the best they can do is a 10% plan. And sometimes that even has to be altered down the road because of unforeseen circumstances, down to a 5%, or as low as I've even heard of a 3% plan. You don't see those too often. But even something like that. And that's what they're going to get. The creditor will get 3 cents on the dollar, or 5 or 10, depending on what the plan says. So that's pretty much how that works. And what the attorney does when they sit down with the person who has to do a Chapter 13 is try and estimate what that will be and put that in the proposed plan and see if that's actually going to fly. To finish up the Chapter 7, all you got to do is take that second course, the Personal Financial Management course, and about 2-3 months later, you're going to get a notice of discharge, and then they close the case. And that's pretty much it. In Chapter 13, of course, it's going to last significantly longer, and they will close the case after you've made your payments. Well, some Chapter 13s fail, either because the person, for one reason or another, stops making the payment, or sometimes they've had a change of circumstances. And in some cases, they actually find that their situation has changed so that they actually can convert that to a Chapter 7 and put an end to the whole thing. So the Chapter 13 is going to follow through the plan through that 3 to 5 years otherwise. Now, there are some rules for somebody in a Chapter 13 that makes the whole process a little more annoying. First of all, they can raise it if your income goes up, which for some people it will, and that sort of thing. But it usually doesn't change a whole lot, and sometimes you can kind of talk around that one. The other thing is, of course, you're limited. You cannot obtain any other credit during that period of time. So you're not going to be able to, let's say, buy a car without the approval of the trustee. Of course, you have an accident, something like that, you lose your car, or you have a need for that sort of thing. It's basically making a bit of a case that your attorney would make for you and this sort of thing, and ask for, look, we need to buy a car. You end up going to a car dealer, talking to the guy, the finance guy in the back office, and saying, look, I'm in a Chapter 13 bankruptcy, but I think I'm going to be able to buy this car, and I want to trade this one in, which is on its last legs, and I want to get another one, a modest car, that sort of thing. If he's a sophisticated financial guy in a dealership, he'll know that this can work. He draws up the whole thing, and it's submitted then to the bankruptcy trustee. And if the bankruptcy trustee thinks it's going to work, then the court will approve it. So you'll be able to get credit that way. Okay, now, since this was supposed to be involved with real estate, and some people, of course, are concerned with that sort of thing, what about other real estate? And when I say other, I mean something other than the house you're living in. Typically, maybe another house that you're maybe renting or something like that. And it includes actually any other, say, real estate that you got some interest in. You might have jointly held property that you hold with somebody else, not your house with your wife or husband, but with another piece of property that you've joined in a partnership with or something like that. No exemption for that property, okay? The other thing you don't get an exemption for, unless you're living in it, and that's a house where you own a life estate, or what's maybe more common is your parents have the life estate, you are a remainderman. You heard mention of that in one of the other lectures, that basically that's one way of estate planning for a house. We want our house to go to our kids. What can we do? Well, you can deed your house to your kids and retain a life estate. You are the owners. When I say that, I mean the parents are the owners as long as they're living. And they're also the ones paying the mortgage payments, insurance payments, taxes, and that sort of thing, including the break they get on the taxes for their age and that sort of thing. But when they die, automatically, and without any estate probate or anything like this, that house then belongs to the kids, who are referred to as remaindermen. Probably today should be remainder person, but nevertheless, that's the old term. And that's a problem, because some of the kids, they've either forgotten or weren't even fully aware when it happened that they are remaindermen, and then they're filing bankruptcy and they find that, oh, there's a remainder interest in a house. Now, what is the value of that remainder interest? Well, if the parents are fairly young, and when I say young, I'm talking youngsters about in their 50s or something like this, then your interest in it as a remainderman might be close to half what the value is. That sort of thing. As the parents get older, the remainder interest grows and the life estate shrinks until you get up to about, say, in your 90s, and the person with the life estate only owns about 10% of the value. There's a chart that's put out by the IRS that shows. You plug in the age, and it'll tell you what the percentage is. And that's what the trustee will go by. And the trustee will say, well, gee, you have this remainder interest in your folks' house. Oh, yeah, but, it isn't like I'm living there, or it isn't like I can do anything about it. They have a life estate. Oh, yeah, well, you have a remainder interest. That's worth something. So somehow somebody's going to have to buy out that remainder interest from the trustee. Otherwise, supposedly, the trustee could force a sale of the property and division, that sort of thing, or could find a buyer. There are buyers out there for remainder interests who would be happy to wait for these aging parents to finally be gone and leave that purchaser with the value of the house. So there are ways you can get around that. Maybe you can use a wild card to, if you can. If you don't have a house of your own, you may be able to apply the wild card to the value of your remainder interest and that sort of thing, or pay off the trustee for a period of time. Which is why when parents come to me and say, I want to deed the house to my kids and take back a remainder and take back a life estate, I say, well, okay, tell me about your kids. How are they doing? Are they on the verge of a divorce? Are they on the verge of something that may lead them into some financial difficulty? Are there judgments against them? Because if there are judgments against them, those judgments will become liens on their remainder interest and eventually theoretically would have to be paid. So those are appropriate questions to ask. And if you have kids who are, not doing that well or have some problems and might be facing a bankruptcy, probably best not to do this idea of transferring the property to them and retain a life estate. Okay, that's about it there. Now, what if I'm a landlord and my tenant goes bankrupt? That's one of the features of a bankruptcy I probably haven't even touched on, is that executory contracts, an executory contract is simply a contract that, although it's been signed and agreed to and everything, it hasn't been carried out. A lease is an executory contract because it's for a term of a period that you're going to occupy or rent something, that sort of thing, over a period of years, but it hasn't fully executed. A lease of a car, that's an executory contract. Well, as a person who's gone bankrupt, you can break these contracts and say, I don't want to do that anymore, and you can walk away from the contract. And a lease can be broken, so if you're a landlord and your tenant goes bankrupt, that lease can be broken by the tenant who says, I don't want to do this anymore. Well, of course, then if he leaves, that's fine, if the tenant leaves. Or you could say, well, that's fine. There's the old lease is gone, so if you want to stay, I'm going to raise the rent a little bit. An odd thing is, of course, what does he owe? Is the tenant behind on the rent? Hopefully not, but if they are, the rent before the filing date is part of the bankruptcy. And if he gets a discharge of bankruptcy, he may get discharged from having to pay that back rent. If there's rent after the filing date, well, that's different. That's called an administrative expense. I mean, that's something that's not covered by the bankruptcy, and the tenant would owe it. If rent is, and by the way, the odd little rule there, number 4, is if rent is 30 days overdue, at least, and also paid within 90 days of filing, it can be clawed back. That is, if you, as the landlord, got paid the rent recently, and it was over 30 days overdue when it was paid, then the trustee can say, okay, landlord, you got to give up that rent. That's really money that belongs to the bankruptcy estate, so we'll take that. There's a number of myths about bankruptcy people have raised, and these came up right after they made the changes in bankruptcy law that they did in 2005. They thought that Congress had eliminated bankruptcy for the little guy, and that simply isn't true. It's a little tougher to do a Chapter 7 and walk away from the debt, particularly if you've got some decent income. But it doesn't really change that much. Bankruptcy ruining your credit record. It used to be, by the way, that you get it's kind of a black mark on your credit report, and it will appear on your credit report that you filed bankruptcy and that sort of thing, and that's it. Nobody's going to lend you a dime ever again. Well, that's simply not true. In fact, some people come home from their first meeting of creditors, and they check the mail, and there's 2 offers for a credit card in the mailbox. And these are from banks that know you filed bankruptcy. And they know, well, number 1, you're not going to be able to file bankruptcy again and get a discharge for at least 8 years, okay? So that's 8 years they can get some business out of you. Secondly, they're usually more modest credit cards. That is, they'll give you a credit limit of maybe $500 or something like this. And the interest rate won't be low. It's going to be fairly high. But nowadays, people usually need a credit card. In fact, often when people come to me, I say, look, you got credit cards? What do you have? Do you have any small ones? And somebody have a credit card with $100 on it. I'll say, look, pay off that $100 credit card. If you've paid it off, then you owe zero. If you owe zero, you don't list it because it's not a debt. If you don't list it as a debt, they don't get a notice. If they don't get a notice, well then, you may go along and continue to use the credit card. As long as you're sensible about it, use it. Nowadays, we use plastic as money. We buy everything, groceries. But the trick is pay it off completely at the end of the month. Don't carry over any balance. If you can force yourself to do that, then that's a good use of a credit card. But just carrying this increasing balance is just going to put you right back in the same shape that led you to bankruptcy to begin with. And along with this, I can't afford to hire an attorney for my bankruptcy. That's unfortunate, but what I usually point out is people come into me and they'll say, look, we're getting killed with these payments. We can't keep them up. I said, how much are you paying out for your credit card? Well, all we're doing is paying the minimum payment, but I got this one, this one, this one, this one, this one. I'm paying out, $300, $400, $500 a month, and that sort of thing. I said, well, okay. It's going to cost you about $1,500 to file a Chapter 7. If you stopped paying now, these credit cards, and if you've decided to go bankrupt, you might as well stop. No, don't give them any more money. In 3 months, you'll have, pay me the money or pay an attorney the money for this, and you'll have enough to actually go bankrupt and be released from all of this. So. Some people have chosen to go the debt counseling service way, and there are debt counseling companies who will try to negotiate for you and to take care of them. And people who advise against bankruptcy as a general rule will give you certain techniques and tactics. Take care of the little ones, get those out of the way. Look for the ones with the highest interest rates and begin paying down on that. Pay the minimums on the other and stuff like this. But of course, you have to pencil and paper this out so to figure out whether this actually is going to work over the period of time. And for some people, it won't. But these debt counseling services sometimes can get a person through this and hold off the banks from suing you, which you want to avoid, and getting a judgment. So if they get a judgment against you, they can grab things like bank accounts. They can garnish your wages, taking 10% of your wages. They can grab other things, and of course, if they file a judgment against you, which they would in the clerk's office, it becomes a lien on the house you're living in. So all these reasons to avoid that. Also the myth, bankruptcy cannot get rid of debts like student loans and taxes. Well, that's usually true. Taxes, by the way, is another one that you usually don't get out of, but not always, and there are, of course, exceptions. One of the hardships, by the way, and didn't mention in the student loan problem, is if you happen to go on Social Security disability. For the student loan people, that is enough showing of hardship that they will just cancel the rest of your student loan. So something to think about. Number 8, I can handle my bankruptcy myself. Well, there are, of course, do-it-yourself things if you're an avid do-it-yourselfer, but this is a heck of a thing, and it's easy to kind of screw it up. So obviously, as an attorney, I say, oh, come to me or somebody who does bankruptcy a lot, and that sort of thing. 9, I won't be able to buy a house or a car or rent an apartment after bankruptcy, and of course, you can, under certain circumstances, do that. Even buying a house, you may not pass muster with a lot of banks for getting a regular mortgage, but you may be able to buy a house and have the seller be the lender. In other words, you do they'll take back a mortgage on that. Number 10, I don't want to go through a difficult time and consuming court case. Well, they're usually not long and arduous court cases. They're usually fairly simple. And finally, any lawyer can handle a bankruptcy. Oh, it would be good if it were true. And as a matter of fact, years ago, almost every general practice lawyer I knew did bankruptcy and that sort of thing, but that's when everything was on paper. What separated the sheep from the goats was when they said, okay, everything's got to be electronically filed, and that's the only way you can do it. And there was a lot of attorneys, particularly older guys, and who said, the heck with that, I'm not going to do this sort of thing. I don't even have a smartphone. Okay, but that's it. Well, that's about the size of it. Any other questions on this? Yes?
Utilities. Utilities being, are they exempt or are they?
They can be. The oddball thing with utilities, if you tell the power company, yeah, I owe you guys $800. I ain't going to pay you the $800 filing the bankruptcy. And the power company say, okay, but if you want to have service every month, you're going to have to give us a deposit. That'll be $500, please, or something like that. So I usually say, gee, if you want to keep up anything, keep up your mortgage and your car payment if you're keeping the car and everything like that, and keep up your utilities, you know, because that makes it better. And I've never seen that criticized as being, oh, you shouldn't prefer one creditor over another by paying your utilities. Now, you need the utilities. So. Anything else? Gee, I'm glad you guys stuck it out.
New friends, new opportunities, new partners. E.G. Tax.